Committee of the Whole is now in session. I had asked that we hold this separately from yesterday's edition of the Committee of the Whole. One, we already had a very packed schedule that lasted as long as I think people expected it to. And so anyway, I know there's two sides that are very passionate about this issue, and I wanted each side to have a chance to make their case sufficiently. And so before we get started, I'm just going to read the recommendation from Mayor Hayward there. And in order to be able to discuss this, we'll need a second and a motion and a second. Recommendation is that City Council adopt modified minimum standards for services and activities at Pensacola International Airport.
For the purposes of discussion, I'll make the motion.
Okay.
Second.
Okay, there is a motion and a second. Ms. Crawford, sorry.
Good morning again. I respectfully apologize for the delay. We are here today to discuss the airport's minimum standards. And I had not anticipated doing this, but I thought maybe it would be in the best interest if I gave you an overview of what the minimum standards are and how we got to this point. As you can see from the audience, it is a very involved and a very, it's a subject that several people are interested in. Basically, the FAA recommends that an airport establish a group of minimum standards, and it governs the aeronautical activity on the airport. It sets the leasehold requirements, it sets the activities, the number of people to provide the services, and things of that nature. It's to promote the safety, the well-being of the airport, but one of the main things, it promotes a level playing field among all that are involved with it, and it promotes, and they should never be unreasonable, or they should not contain any unjustly conditions that would create discriminatory practices. You know, as the FAA provides a great deal of your funding, every grant that you receive from the FAA has grant assurances assigned to it. And one of the grants assurances, 22 and 23, deal with not creating exclusivity, and then 22 deals with non-discrimination on the airport. When a new provider comes on, or a provider comes on and decides that they want to provide a certain service at the airport, they can go to the minimum standards. It will define what is the exact spaces they are made to lease. It defines the hours of operations. It provides everything that's a guideline to them in the operation of their performance of their services. The FAA has a very unique role in this. They do not require minimum standards, but they strongly recommend them. They do not approve minimum standards, but they will give you a cursory review of them to see if they believe that you are in conformance with your grant assurances. The other issue is that the FAA will be the determining factor if there is a Part 16 complaint. And let me just give you an overview of what a Part 16 complaint is. If an entity feels that they have been unjustly discriminated against, or if in any way we have violated their assurances associated with their activity, they can file a complaint. A Part 16 complaint is not punitive in nature. When the FAA reviews it, they do not set penalties, but they do determine if some portion or all of our minimum standards are in violation of our grant assurance. They encourage us, and they oversee us while we bring those minimum standards into compliance with their guidelines. The FAA does provide, the other issue that I would bring in is the FAA does provide an advisory circular that we use as guidance when establishing our minimum standards. You know, this has been a very long and drawn-out process, and I thought it might be well to just go back and just, in my recollection, what were the steps that we've done and how we've got to this position right now. The airport did not have minimum standards until 1998. Frank Miller brought over his minimum standards from Junction City, Colorado. They were modified and we put them into place. A lot of times airports use documents from other airports to help them in the creation of their documents. We did review our minimum standards in 2004 and we updated it to revise it to allow some different acts and functions, but I'm not even, right now, I don't recall exactly what that was in 2004. There is a provision in the advisory circular. We are to review our minimum standards periodically, and if there is something that causes them to be out of compliance with our grant assurance, we're to address it. The FAA's advisory circular also says that once an airport sponsor receives a proposal of new aeronautical business, it is our requirement to go in and determine whether or not that the existing minimum standards can be used or whether or not they need to be modified or new minimum standards need to be established. And that's the airfield layout of our airfield, and as most of you are aware, the entities that are involved in this revision of the minimum standards would be HeliWorks. They're a SASO that provides helicopter repair. We also have SASOs and a SASO is a specialty aviation service operator. You have Navy Flying Club, Echo Air, Innisfree, Lifeguard Air Ambulance, and let me review who these are. Navy Flying Club is a flying club. It's a private group. Echo Air is currently not in business, but it provided avionics and maintenance. Innisfree is a hangar. They provide hangar management for their own aircraft. There was, in their initial development, they were looking at possibly being a 135 provider, which is a charter. Lifeguard Air Ambulance is a 135 provider. They provide, in addition to organ harvesting and things of that nature, they do provide aircraft charter. And then you have your fixed base operator. Your fixed base operator basically provides, according to the minimum standards, they are the ones that are allowed to provide fuel, not only to the general aviation, but they also can provide in-the-plane fueling for the airlines. In order to become an FBO, you have to provide primary services, which is fueling, line services, and maintenance of aircraft. There is a provision within their agreement and within the minimum standards that our FBO does not have to provide maintenance to both jets but they do have to provide maintenance to the turbine. Their secondary services, they have to provide 2 secondary services. Currently, they provide hangar keeper, which is here, and they also provide flight training and 135 charter. I would like to make something very clear that this is not an Innisfree PAC issue. This is an airport issue that we've identified that we believe the minimum standards need to be revised in order to promote competition on the airport, and that we are here to address how we're revising the minimum standards and how that's going to achieve that competitive promotion on the airport. As a little bit of background, Pensacola Aviation used to be located adjacent to the terminal. They've been a good provider on the airport for aeronautical services over the years. In the early 90s, it was determined that because of the growth that was going on at the airport, that it was not viable for general aviation to operate on that airfield, on that ramp. General aviation, in addition to handling privately owned aircraft, they also handle the military activity that takes place on our airfield on the weekends and when the other airfields are closed around the area. So there was a lot of activity going on that airfield. So the airport, with funding from the FAA and FDOT, and going through an extensive environmental assessment and public hearing meetings, we used about $4.2 million of our grant funds to develop a 500,000 square foot ramp. We built all of the parking in that area. We built all of the infrastructure for stormwater. And we built the road into ingress and egress. In return for agreeing to move from their existing facilities next to the terminal, PAC was given an exclusive lease for this area, and their lease rate is it was set at that point in time by an evaluation, and it's been increased 2 times, and it's currently a little over 7 cents a square foot for their leasehold. To put this in perspective, the other entities on the airport in Heliworks, Southern Company, and the SASOs pay a minimum of 30 cents a square foot to be on the airport. The other benefit for an FBO is that due to state statutes, they do not have to pay ad valorem tax. They're exempt from ad valorem, but the SASOs are not. One of the unique things that happened to the airport when we relocated those businesses over to that section, and it was a good decision because otherwise the terminal and the actual lifeblood of the airport, which is the commercial operations, just to put it into perspective, we get about $3 to $4 million in terminal rents from the airlines. From all of the general aviation activity, we get about $200,000. So often the airlines and the other functions of the airport subsidize general aviation, but general aviation is a viable and a needed activity at the airport, and that's not uncommon for most airports to subsidize general aviation. The only items other than the ground rents, we do get a fuel flowage fee. Every time they sell fuel into a general aviation or a non-airline aircraft, we get, I believe it's about 6 cents a gallon. If you look at the configuration of the airfield, when we relocated Pensacola Aviation over to that side of the airfield, the neighbors in that area responded with some concerns, and we were sued. As a settlement for the lawsuit, we agreed that we would never come in and develop any more general aviation activity with the thought that build it and they will come. If the only way that we could build it is if somebody indicated an interest or desire to be a FBO or another provider over there, then we would be able to start putting it in our planning documents and start funding it. To put it in perspective, to create another FBO, to go through the design, the development, the funding, it was probably about a 5 to 10 year a 5 to 10 year period. And we have never had anyone that came in and said that if we build it, they would come. The other little caveat is that if we build it, we cannot build it for an explicit person. You cannot build a ramp for an exclusive use. If we build a ramp, and it must go out for an RFP, and then it would be awarded to the proposer that was the most acceptable. We've never put it in our planning documents. We do not have the funding. As you know, we've spent nearly $50 million on runway reconstruction between '99 and 2008, and then we spent $80 million on terminal rehab. We have not made that a priority as far as developing or expanding it. But what we did create, and I will go into detail in a few moments, we created a very big barrier of entry for any competition coming into this airport. We built 500,000 square foot of ramp, which at that time, when PAC was over at the other side of the airfield, they had less ramp space. This was an increase in the ramp space, but over the years, general aviation flows like this. You have peaks and you have valleys. And during high times, 500,000 could have been applicable. Have we been seeing that type of activity? Not for a long, long time. We do not have the funding or the capability to come in and build a similarly situated facility that would allow fair and equitable competition on that airport. We don't. And I'll get into that in just a few moments, okay? If you have any questions, stop me as we're going. In 2010, well, you can actually see Mr. McQueen, I'm not sure when they built their hangar here, and again, I was not going to bring this as an Innisfree PAC. I brought Innisfree's name in here because for the specific reason that a while ago, when I mentioned to you that the advisory circulars say that I have to address, if somebody comes to me with a request, I have to address it. In 2000, Mr. McQueen put in some fuel tanks in '04 for his own personal use. Over the years, he's expanded his use to include affiliates, and there probably will be some discussions about that later on today, or this morning. But I was not at the helm at that period of time. I was in 2010 when Innisfree came to us and they said that they would like to sell fuel, and they cited that the lack of competition on the airport was promoting high fuel prices. And the airport contacted with Aviation Management Consulting Group to perform a review of our minimum standards. And because it was very explicit that Mr. McQueen, Innisfree, had asked that they wanted to be an FBO, we asked the gentlemen, the individuals at AMCG, to go in and review to see if he could, or if that business could comply to the minimum standards, and if they could. And this is exactly what they wrote. Innisfree does not comply with the current FBO minimum standards in several areas. The city could reject the company's proposal to engage in FBO activity. They did identify several what they perceived as deficiencies with our minimum standards. They said our wording wasn't quite right. They said that there was some formatting issues, that we didn't use certain words the same way in several areas. I would ask council's indulgence. Some of you were here, some of you were not. But in 2010, when I took over, I used to be your assistant director for finance. I would have handled this. I became your airport director, and the position of assistant director for finance was not filled. And I'm very grateful for Mr. Kobe for not filling that, because he thought that if I didn't do you a good job as airport director, I could always go back down to finance director. So I was very happy that. But it was a very difficult time. We were in the middle of an $80 million project, and I honestly reviewed AMCG's review, and I did not feel that there was anything in there that was life-threatening, that was truly creating unfair competition, that was violating my grant assurances, or that was any way impeding the operation of your airport. If I had have, I would have addressed it. I did not. I did not address the report. I did notify Mr. McQueen, Innisfree, that we were not going to be able to move forward based on that review. In 2011, Innisfree again came to us with another request, and once again they cited the lack of competition was promoting high fuel prices on the airport. By this time, I had been your airport director for a little over a year. I'd been going out into different functions, and I was routinely hearing this. It was not just coming from it was not coming from Innisfree only. Other entities were saying the same thing. Can I tell you exactly who they are? Probably not, because I'm going to tell you right now, I do not have a memory for names. I don't have a memory for dates, and I don't have a memory for names. But I do know that it was being brought to my attention by more people than Mr. McQueen. I contacted with AVCON to do a review. The main thing, and this is an engineering firm, I wanted to know, was the infrastructure on that ramp, on the corporate ramp, able to support any type of an FBO activity? They did an analysis of the ramp. They did an analysis of my general aviation activity. And I'm going to tell you, in parts, it was a very good report. In parts, I had some concerns. One of them, they wanted me to lease out. One of their objectives was to do a tier FBO level, and it would require me leasing the entire ramp to Innisfree. Well, I already had portions of that ramp leased out. That was not a viable option. The other thing that I had concerns about, during the AVCON review, I was going to your different tenants, and I was meeting with each one personally. Did I meet with Mr. McQueen and Innisfree on several bases? Yes. Did I meet with Bruce Bennett and Mr. Hutchins on several times? Yes. Have I met with Lifeguard Air Ambulance? One time, because he's a very busy man. I've met with the Navy Flying Club. They've also attended some of the public meetings. I met with Mr. Estes. The other thing that the AVCON report did not do that I had found during my review, by this time I was truly dedicated to finding out all I could find out about minimum standards. The FAA had revised their minimum standards in 2009 or 2010 time period, the current one, and it actually addresses that a SASO has the ability to fuel if they bundle services. Now, when I contacted the FAA about this, the FAA, while they questioned it, they did not even, my person that I talked to, and I will not throw them underneath the bus because this is a public record, but they did not even know that the minimum standards had been revised and that it did allow that language for a fueling SASO. Yes,
Can
ma'am?
you clarify bundling services?
Bundling services is a SASO normally has one service. If a SASO comes in, they have to provide more than one service and in order to have the opportunity to fuel. That's exactly what it says. We did propose in January, when we revised the minimum standards and we presented it to a public meeting, we did say that we were going to request your permission to authorize a fueling SASO. If they bundled service, they would have to provide 2 or more services. They would have to provide the same type fueling as an FBO, and they would have to provide the line services and the maintenance. The only benefit, the only difference was that a SASO would not have the same lease requirements as an FBO, but again, they would not have the ad valorem benefit of an FBO, which is state statute. During our meetings, during the time that the AVCON report was being written and we were in discussions with them, I met with each one of these tenants, and it was during some of those meetings that I truly got an insight as to why certain things were happening with within our general aviation field. And I know that today you probably are going to hear some things that are going to be not in the highest light of me, but my heart was absolutely in the correct place when I met with Mr. Bennett and his associates. I asked them, could you please tell me what burdens are you under due to our minimum standards? At that point in time, he told me, and Mr. Moroney was in my meetings, he told us that he was losing hundreds of thousands of dollars a year on maintenance for the turbine that he does, turbine work that he does. I mean, I'm sorry, you don't do turbine, do you? What is it?
We do both.
Both?
We do both.
You do. Lose hundreds of thousands of dollars a year for maintenance. He also indicated that he was losing hundreds of thousands of dollars a year for flying, flight training, and Part 135 charter. I'll reiterate to you that as a FBO, I truly am grateful for the services that PAC offers this community. But they are only required to offer two secondary services. They offer hangar keeper, and hangar keeper, over the years, the airport has been able to secure over $250,000 in grant to assist them in funding hangars. Hangar keeper is probably one of the more economically beneficial functions. That was the only one that was indicated to me that they weren't losing money on. I asked them, at that point in time, the minimum standards only allowed for an option of 5 secondary services. But the SASOs had 8 services that they could provide. FBOs were not allowed, a secondary service, were not allowed the opportunity to provide aircraft sales, aircraft refurbishment and repairs, or specialty flying services. I asked if we were to modify the minimum standards to allow you to do those, would that assist you in times where you had that ebb and flow and you needed to readjust your business practices to make ends meet? Also, you only are required to have 3 secondary services. You have 3. 2 of them are nonprofit. Eliminate one of them. And at that time, Mr. Bennett made a comment that truly has been a factor in why I've been motivated to look at promoting competition. He said, we lose money, but those are fun things to do, and you meet the most interesting people. And let me bring that into context. The whole time I've been out, I've been hearing that either Pensacola Airport or Mobile Airport had the highest fuel. Both of them had virtually the only ones that had exclusivity or had the only operations on the airport. They did not have any other competition. And after during this discussion, they said that they have a high amount of profitability on fuel, and they use it to support their other activities. So in essence, from my conversations with them, I was told that they were using fueling to subsidize their other activity, and that was causing the higher prices with fueling. During the AVCON report process, Mike Moroney and I were reviewing other items. Again, I found out that there was a revision with the advisory circular that said you could have a fueling SASO. And I believe to this day that we have every right to do a fueling SASO. It's in the advisory circulars, and we have every right to it. The only thing is, I know that it will encompass a very big Part 16 complaint, and it will incur a lot of legal expenses. And since I only make $200,000 a year off of FBOs and general aviation, who do you think is going to subsidize that legal complaint? So we also determined that in 2011, the FAA had contracted. Again, FAA does not have guidelines as far as requirements for specific. They say we have to be fair and equitable. They did a research. They contracted with the Transportation Research Board of National Academics to complete and publish a survey of minimum standards of 38 airports for commercial airports, defining their minimum standards. You know, over the years, There's two things that we do that I have found out that bring a great deal of concern. One is, how do we appraise property? We go to other airports and we ask them, what are you charging, what are you charging? And then we pick the average or the highest of what they're charging. Then we increase our rates, and a few years later they come back. It's sort of like a circular logic that goes around. Same thing goes around with minimum standards. When you've seen one airport, you have seen one airport. No two airports in this world are exactly alike. We have different geography, we have different environments that we operate in, we have different number of operations, we have different amount of military, we have a different amount of capacity issues. No, that's why the minimum standards are not a requirement, and that's why the FAA does not publish their guidelines as far as specific requirements, because they couldn't, because no two airports are the same. If you came to me right now and you interviewed us and you surveyed us about our minimum standards, you will hear that I require my FBO to have 500,000 square feet of ramp. That's unheard of. We build it, they have it, and now I require it. It's no longer needed because of the general aviation activity level at our airport. We held 5 meetings on this subject. And I think that I'm not sure who is presenting this presentation following me, but they have a little bit of different idea about public meetings than I do. My idea of the public meeting was to identify what we were going to be changing, take recommendations as if they, from them and comments from them. It wasn't to go in and to discuss the AVCON report or to be blamed because I didn't put an AVCON report into place, or to be villainized because I didn't put the report from the Aviation Management Group into place. I came into my public meeting on March the 5th. I identified that we were going to propose to you, City Council, at the January 12th meeting, that we were going to ask you to allow for fueling SASOs. We were going to ask you to allow an FBO and a SASO to contract out maintenance, flights training, or flight charter if they elected to, because they have that ability as a business decision, and it was not in our best interest to regulate that they have to do that by their own staffs. I was also going to ask you to allow FBOs to have 3 more options of services that they could render as secondary services, in order that if they do meet a downtime, that they can modify their business plans. And again, at this point in time, I was going to be recommending to you that businesses such as Innisfree could become a fueling SASO, but we were also providing relief to the FBOs in the same thing, contracting out services, additional services that they could offer. And again, this is just an overview. It was determined shortly thereafter, at the first meeting, Pensacola Aviation was represented by legal counsel, and it was determined that we would be among the, during the course of the conversations with them, they did send back a notice saying that they do not want us to proceed. They believe that we will be discriminating against Pensacola Aviation, and that we should be prepared for a Part 16 complaint. We were also determined, I'm sorry?
Is there any way you can, I would like to have that page right there.
Yes,
during
ma'am.
this meeting.
Yes, ma'am.
Is there any way we can get that printed off right now?
Chris? Yes, ma'am.
Can you get me a copy of that page right there?
It was also determined that we would be among the first airports to be able to, that would be allowing a SASO to fuel. And because of that, we would be treading unknown territories. We did secure the guidance or the assistance of an outside counsel who is very knowledgeable of this, and basically we were told that because it would go to the FAA, there would be a 50-50 chance that the FAA would cite with Pensacola Aviation if they should complain, or they could uphold our determination or our revisions to our minimum standards. But one thing that had occurred during this is that we realized that there is a document that is non-biased, that is fair and equitable, that can be used to establish the minimum leasehold requirements. And that's what we're asking you to do. In addition to modifying the minimum standards to incorporate the average or the mean leasehold requirements from the FAA survey, we also are asking you to, again, just as I did in the original proposal, the original draft, add additional services for an FBO to offer, and also allow FBOs and SASOs to contract out certain services rather than to have them provided by their employees. The FAA, I sent the minimum standards that are in front of you. I sent them to the FAA. They are not required to review it, but they did give me the courtesy of a review. And as you can see, in my documents to them, I indicated I am removing all verbiage about a fueling SASO, although I still believe that it would be, the airport had every right to allow for a fueling SASO, but that we are eliminating fueling SASO, that we are using the FAA guidelines, survey guidelines, for our leasehold, minimum leasehold requirements, and that in addition, because of the, and I explained this to them, and I'm going to go back to explain this to you, the configuration of our airfield and our existing pavement will make it virtually impossible, even with the existing leasehold, if you reduce the leasehold as proposed, it will make it virtually impossible for somebody to come in unless they come in and put in the expense at their own dollar of putting in additional ramp, additional infrastructure, additional parking. And then they will not be able to compete on a level playing field with the existing FBO. The only way that it's going to be possible is if we allow, there's a provision in our existing minimum standards that say that the pavement ramp has to be contiguous and adjacent. I'm asking for your permission to remove that in order to have enough pavement on the airfield for somebody to be able to come in and to become an FBO. And again, if you will read the response from the FAA, I think that sums it up very, very adequately. We also believe by using the industry's average square foot requirement, it appears the city has set a standard that is obtainable and fair. We also believe the offer for existing tenants to reduce their leasehold to the new standard is more than fair. I had indicated to the FAA that if our minimum standards are approved as presented, I will go back to my existing tenants and allow them to reduce their minimum leasehold if they feel that it's in the best interest of their business. To go on, I'm sorry.
Can you go back and clarify on the map, and you said in the 1990s, this is when PAC was asked to move.
Yes, ma'am.
And they entered into a new lease, and there was another FBO space contemplated at that point when you were construction?
Your airport layout map or your master plan identifies that area as future FBO general aviation development.
Future, so there's no pavement in place for that second FBO.
The lawsuit prevented us from coming in and doing it unless we had a specific individual that was, and then to add to that, the issue that if we build it, it cannot go, we cannot build something for one person or one company. It has to be opened up for a fair competitive bid. Now, when Pensacola Aviation was moved over there, we did not go out for requests for proposal. I don't know how that was done. I believe that they had the existing lease and it was a relocation to this new. It was significantly increased, but there is in the master plan identified an area for
So the
future.
private lawsuit from the residents prevented you from using grant money to pave the remainder so someone could?
Prevented us from even putting it in our planning documents with the FAA or with the Florida Department of Transportation.
So there was not a second FBO planned when you,
Only in the master plan. It was never put into any funding mechanism or anything of that sort because we were not allowed to due to the lawsuit.
okay. And I'll save my other questions for later about that. I'm just trying to get it straight. Thank you.
You know, I have one thing that I would like to just to bring into context. This is the whole crutch of the issue. I'm sorry if I shoot you, Mr. Reynolds. Okay. I'll put this up, and I don't want to. Oh, that would be the best place to put it right here. I'll put it right here.
There's an easel behind you.
All right here.
Put on my sunglasses, y'all excuse me.
Okay, get your glasses on.
The only problem I have with having you like that, I'm sorry to.
I'll bring it to you.
No,
the glare.
is that
Got
the
glare.
public can't see it,
Oh, okay, I'll turn it around.
but then we can't see it.
Come on up to right
But I'm
here.
thinking
Gotcha.
coming up here.
And that'll solve the glare, too. I had some glare.
That's good right there.
Right there?
I think most people can see it.
All right. There is an entity that provides daily fueling prices that are going on, and you can put in a location, and it will give you within 50-mile radius what the fueling prices are going on. I will caveat this, that this does not include Mobile Airport. If Mobile Airport was included in this, it would be running about, usually Mobile and Pensacola run first and second, and the rest. Would you just note the variance between, I'm not saying that they didn't have every right to charge these fuels, but you'll notice that this variance has come down to this point right now where they're in line. And I'm not sure if I'm allowed to say this, Mr. Russell. Can I tell you what my opinion is why it's come down this way?
Sure.
The potential or the possibility for competition is driving that variance down. And that's basically, I just wanted to let you know, my goals and motivations, I'm not motivated by anything other than that. As your airport director, and I'm going to tell you right now, in my professional opinion, and I am an airport professional. I've been accredited. I have over 17 years of airport experience, and I'm going to tell you that it is in my opinion, as your airport director, that improving competition on this airport through the modifications and revision of our minimum standards is a viable and an important thing to do. I would not have spent months on end with this issue if I did not believe that this is the right thing to do. Mr. Reynolds?
All right, Ms. Crawford, thank you very much. When Mr. McQueen had called me yesterday, he indicated that they didn't have a presentation, but they're available here to take questions. It looks like you guys are lined up for a presentation, is that right?
Yes, sir.
Okay. And feel free to interject yourself into the presentation at any point. I can't always see you when I'm sitting here looking up at the front screen, so if you got a question, just speak up.
Question I know is want to say something.
Yes, sir.
I'm waiting for Chris to get me hooked up here.
Okay, well, we've got a gentleman from the public here.
My name's Richard Jesmont. I'm a local attorney, and it's been my pleasure to represent Lifeguard Air Ambulance for over 20 years. I would like the airport director to please amplify something she said, because it kind of is a segue into what we're concerned about. You indicated that you didn't think there was adequate parking, adequate ramp space, and a few other things that in your opinion, you just sort of came in there. If that's true, where would the new FBO go?
I'm sorry, I didn't get your name.
My name is Richard Jesmont. I represent Lifeguard Air Ambulance.
May I respond?
Yes, ma'am, please.
Mr. Jesmond, I did not mention anything about parking. What I did say,
No, ma'am, you did.
aircraft parking. Ramp and aircraft parking.
I'm going to have to ask you to sit down if you start taking a
But I
belligerent
do
attitude.
believe there is there is additional pavement on the airport if the provisions for adjacent and contiguous are removed, that it would allow for the requirements to be met.
Well, do you want me to respond after?
Yeah, I think it'd be better, just let these gentlemen do their presentation, and we're going to open it up for
Yeah,
discussion.
we don't have any particular objection either way. We do business with both of these parties, but we just have some concerns of our own that are independent of what they want to do.
Okay, that's fine, then. Just want to warn you, though, that if you get up to speak again, belligerent doesn't help your case.
Well, sir, I appreciate that. I think Mr. Spencer's known me a long time, and belligerent might be my middle name, but I'll try to keep it down.
Okay, all right, thank you.
Good morning. I'm George Walker, and I represent Pensacola Aviation Center. I appreciate you providing us with this time to be heard on this issue. You have a committee memorandum dated today from the mayor, and I'm not sure who prepared it, but there are several errors in it I want to bring to your attention at the outset. In the second paragraph on the first page, there's a statement that in 2011, staff received a formal request from a tenant to upgrade its business to a fixed-based operation. Actually, the formal request came in 2009, and the truth of the matter is, since 2004, Eros and Innisfree, I may say either one, it's the same entity. Eros owns Innisfree Jet Center, has been pushing to sell fuel at the airport. And let me go back to start this way. I think city council members should rely on the managers of city facilities. Ms. Crawford is a distinguished professional. Y'all have hired her and put her in a position out there. And when a manager makes a recommendation, in most cases, the city council ought to presume that the recommendation ought to be followed. And I understand that I'm walking uphill in asking you not to follow that recommendation. But I'm here today to ask you not to indulge the presumption in favor of that recommendation. And I'm here to ask you to reject the recommendation to revise the airport minimum standards because the process that was used to reach that recommendation was flawed. I ask also that it be rejected because the minimum standards as proposed will violate FAA grant assurances and put at risk the federal funding. And I also ask that they be rejected because adoption of the proposed minimum standards will violate Pensacola Aviation Center's constitutional rights. But let me go back. I said there were 6 errors in the committee memorandum. I told you about the first one. The second one is the statement on that same paragraph about the fixed base, the special fixed base operation as defined by the FAA advisory circular. That advisory circular does not mention special FBO. It doesn't even talk about FBOs as I read it. And it was revised in 2006, not 2010, as Ms. Crawford stated to you. The third thing, Section 1.2G of the FAA advisory circular refers to new aeronautical businesses. You heard her talking about that. Eros has been at the airport for 8 years. It's not a new aeronautical business. It's trying to change its business plan, but it is not a new aeronautical business. And the memorandum, it quotes language down there at the bottom from Section 1.2G, but it omits this statement from the FAA advisory circular. Quote, in all cases, the airport sponsor must ensure that in changing the minimum standards for whatever reason, it is not applying unreasonable standards or creating a situation that will unjustly discriminate against other similarly situated aeronautical service providers. And the airport has done nothing in connection with this proposal to ensure that it meets that requirement from the FAA. The fourth problem with this is it states that it's based on a review of the existing minimum standards. There have been at least 3 reviews, professionally performed reviews of these minimum standards by highly paid consultants that the Pensacola city taxpayers have paid for. And those reviews do not support allowing Aeros to fuel independent aircraft, which is the primary goal of these proposed revisions. And the airport has chosen to ignore the recommendations that were made by those consultants. The fifth error in the committee memorandum is in the last paragraph on the first page, where the airport cites as an industry standard, and I'll say quote industry standard, close quote, the 102,000 square foot average ramp requirement identified in the February 2011 survey of minimum standards. That particular document had 38 responses of, I don't know, 100 or 200 different airports consulted. 497 airports were surveyed. 38 of them responded with minimum standards related to ramp area, and the average ramp area of those 38, and we don't know who those airports are or where they are, was 102,000 square feet. And the airport presumes in making its recommendation to you that the average FBO ramp area for those unidentified airports is sufficient and proper for an FBO at the Pensacola airport. And the FAA, in the same advisory circular that Ms. Crawford was talking with you about, recommends against that type of thinking in section 1.2C under the topic developing minimum standards. The FAA says, quote, minimum standards should be tailored to the specific aeronautical activity and the airport to which they are to be applied, close quote. Don't go out and get some average from 38 unknown airports. You have to tailor it to your own airport. And the FAA goes on to say, for example, it would be unreasonable to apply the minimum standards for a fixed base operator at a medium or large hub airport to a general aviation airport serving primarily piston-powered aircraft. The imposition of unreasonable requirements illustrates why fill-in-the-blank minimum standards and the blanket adoption of standards of other airports may not be effective. The last error in the committee memorandum is the suggestion on page 2 that the airport's recommendation is in compliance with an FAA document. That's absolutely untrue. I don't believe that anyone here today will be able to identify any airport with Pensacola's level of aeronautical activity that has ramp space requirement as low as the 102,000 square feet that you are asked to approve today. And let me talk about this while I get to that point. As the city of Pensacola, if you want your airport compared to the airports at Gulf Shores, Destin, Crestview, Bay Minette, Fairhope, and Bruton, then maybe this isn't a proposal for you, but I would think you would be interested in being competitive with airports like Mobile, Gulfport, Tallahassee, Northwest Florida, Panama City, Montgomery, airports that are truly similar to this airport. Those airports are not similar to this airport. I don't know where the data came from for that chart, but I can tell you, you can make the data look however you want to as long as you control where you get it. And if you go out and you look at small airports, you will be able to find cheaper fuel. Just like if you go into certain areas of the state, you're going to find gas for your car cheaper than in other areas. If you try to buy gas near an airport, you're going to pay more because rental car returns are filling up near the airport. If you buy it further down the road, you can get it cheaper.
Just one moment. Where did your data come from, Ms. Crawford?
It comes from that, right there, it's sourced on the thing, it's the AVCON.
AirNav, okay, thank you.
Mr. Hall, may I respond to the 6 errors?
Well, let's let him finish. You'll have an opportunity for that.
The history of this, I think, will and I'm going to take longer than I meant to, but I think it's important that you know the history in order to see where you are today. It's hard to know where you're going if you don't know where you've been. In 2004, AROS became a SASO, a Specialized Aviation Service Operator at Pensacola Airport. By December of 2010, it had already made known its intent to fuel independent aircraft. In September of 2007, AROS gained approval to install fuel tanks so that it could fuel its own aircraft. And in May of 2008, the City Council approved Amendment Number 1 to the AROS lease agreement, which allowed AROS to fuel its own aircraft. In June of 2008, it was reiterated to AROS that it was only allowed to fuel aircraft that it owned. In July of 2008, AROS asked to be allowed to fuel aircraft owned by its affiliates because it turned out that AROS didn't really own any aircraft itself. It had a partial ownership. And the airport director at that time, Frank Miller, was concerned at the request. And I will say that the items that I am referring to and quoting from are all in your notebooks, as is this PowerPoint. I have 30 exhibits in there that you can look at at your convenience. In January of 2010, the airport hired Aviation Management Consulting Group to analyze the content and the reasonableness of the minimum standards. And that was at a request made in December of 2009 by AROS that it be allowed to sell fuel to independent aircraft. And AMCG issued its report on March 15, 2010. AROS, according to AMCG, did not meet the minimum standards to be an FBO at the airport. It didn't have enough land or ramp access, parking, hangar space, or fuel storage space to act as an FBO. And AMCG identified a number of deficiencies in the minimum standards as they were written, and as Ms. Crawford told you, those minimum standard problems have not been, or deficiency has not been corrected yet. And Pensacola's taxpayers, I believe, paid $5,000 or more for that report. When that report did not support AROS's plan to fuel independent aircraft, the airport went on to ignore the recommendations in that report.
What was the date on the AMCG?
It's March 15 of 2010. On March 22nd of 2010, the airport management sent the AMCG report to AROS, but not to any of the other airport lessees or stakeholders. Apparently, while all this was going on, AROS was, although it wasn't an FBO, was acting like an FBO and continuing to sell fuel to independent aircraft. In May of 2010, Mr. Wells, who was the city attorney at that time, wrote a letter to Mr. McQueen about it, and apparently he referred to a long history of correspondence from the airport advising that the lease does not allow Innisfree to have and fuel aircraft not owned by it. So according to this letter, this had been going on for a while. In July of 2010, the airport was still discussing the Innisfree question, according to Mr. Godwin, the airport's counsel, even though the $5,000 AMCG report had answered that question 5 months earlier. In April of 2011, we got to about where we really start with the process that we're talking about today. The airport acted as if the AMCG report had never been received and commissioned a new third-party review of the minimum standards. At this point in time, and even today, the airport had not made any of the modifications recommended by AMCG. In May of 2011, the airport hired AVCON, Inc. To conduct that third-party review and agreed to pay it an additional $17,928 of taxpayer money because AROS still desired to be an FBO. One thing they did not ask AVCON to do was to compare For example, the prices charged by the FBOs in Pensacola with those in any other location. The scope of work document between AVCON and the city for this project set forth AVCON's responsibilities. Particular one of interest to us is number 4, recommend modifications to the airport's minimum standards if warranted. And that was one of the responsibilities that AMCG had been paid for a year earlier. AVCON issued a preliminary report, and then on November 1, 2011, a final report finding, like Mr. Wells had mentioned in his letter a year earlier, that Aeros had already essentially been operating as an FBO, and apparently the airport had not been enforcing the lease limitations. AVCON proposed that the airport create a new, quote, general aviation FBO, close quote, so that Aeros would be able to sell fuel and compete on fuel prices. AVCON's proposed specific requirements for the general aviation FBO, and Aeros could not meet those requirements. You'll notice one of them was 152,460 square feet of airport parking apron, or as you'll hear, otherwise ramp. The AVCON recommendations were never adopted. When I asked Ms. Crawford and her consultant, Mr. Moroney, why at a public hearing, they said they'd get back to me. They haven't gotten back to me. But we know that the airport ignored the recommendations of its $18,000 consultant because it did not provide a way for Aeros to fuel independent aircraft. The airport instead adopted a plan to create a fueling SASO. That is a SASO that, unlike SASOs at any other airport in the country that we've been able to find, would be allowed to sell fuel. This was the plan that they proposed to submit for your approval back in March, and Aeros would have been the only business at the airport that would have qualified for this. But the airport scrapped this fueling SASO plan a few months later when we made it clear to them that the plan would not withstand FAA scrutiny in a Part 16 challenge. Apparently they've gotten the same advice from their counsel, if I heard her right today. But the process that they followed with this fueling SASO plan tells us a lot about the motives and the priorities of the airport and its staff. The motives and priorities should concern you as you decide whether to accept the airport's recommendation now. It started with the airport's consultant, Mr. Moroney, producing revised minimum standards and a proposed draft of a new Aeros lease with no public hearing or notice. And even before the AVCON final report was received, the airport's attorney wrote that the minimum standards were going to be revised to allow Aeros to fuel independent aircraft. So from our standpoint, it appears that the decision had been made and that everything that followed after that was simply doing what had to be done to make it look legal. The FAA grant assurances prohibit unjust discrimination. On December 3, 2011, Mr. Asmar sent an email to Ms. Crawford questioning whether the minimum standards must be changed in order for Julian to be a SASO. The mayor's chief of staff was consulting with the airport's director on behalf of Julian. Mr. Moroney, the airport's consultant, was meeting privately with Aeros representatives to discuss revising the minimum standards. By the time Pensacola Aviation received notice of any of this, the revised minimum standards had already been prepared. The revised Aeros lease had already been prepared, all with meetings between Mr. Moroney and the Aeros personnel, excluding Pensacola Aviation and the other stakeholders at the airport. When the public hearing was held on January 5, 2012, the revised standards and the revised lease were already done deals. And the hearing was just held because they're trying to make it look as if there was an opportunity to be heard when there wasn't. Ms. Crawford and Mr. Marcy were not forthcoming at that hearing on January 5. They did not tell us that the city had paid for and was ignoring two separate reviews of the minimum standards. We found out about that when we filed a Freedom of Information Act request with the city. In February, the airport met with AROS again about the lease revisions, and did so even though the minimum standard revisions that were prepared and proposed had not been approved and never would be. On February 20 of 2012, Mr. Moroney proved himself to be an advocate for AROS instead of for the City of Pensacola or its flying public in his email to Mr. Godwin with his comments about the airport's receipt of a letter from Council for Pensacola Aviation Center. Later that week, Mr. Moroney prepared a discussion memorandum in which he made a clear misstatement of fact in his discussion, in his email to Mr. Asmer. He was trying to suggest that AVCON's report supported the revision of the minimum standards, but he knew otherwise. There is, in fact, no reference in the scope of work that AVCON agreed to do that relates to any extent to the advisory circular that he referenced in his email. Mr. Moroney could not identify a single airport that had adopted a fueling SASO minimum standard, and we've not been able to find one either. Yet he suggested in his email to Mr. Asmer that the fueling SASO would be consistent with federal obligations, and that just was not so. On March 2, 2012, the FAA responded to Ms. Crawford's letter containing the proposed revisions regarding the fueling SASO plan, and the FAA, the only fair way to describe that letter from the FAA is that it criticized the fueling SASO plan. Ms. Crawford said later that the FAA had approved the revised minimum standards, but as she told you today, the FAA does not approve minimum standards. Mr. Asmer told her to send a copy of the Henry letter, the FAA letter, to Julian's counsel. They didn't send it anywhere else, and he didn't tell her to send it anywhere else, and she did not do so. Then, March 5, there was a committee memorandum similar to the one today because this was going to be presented to you back in March, and it contained many of the same errors as the current one contains. It referred to an extensive review of the existing minimum standards and stated that the extensive review led to the recommended changes. In fact, the extensive review had been ignored, and all the proposed changes ignored all of the recommendations from the extensive reviews by AMCG and AVCON. What the memorandum should have said on March 5, 2012 was this: the proposed revisions are based on advice the city received from a consultant who was relying upon a piece of language in an FAA advisory circular to recommend that the airport adopt a standard that has not been adopted or implemented in any other airport that the consultant could identify. The email, by March 7, the email trail makes it appear that not only Mr. Moroney, but Mr. Asmer is working for Mr. McQueen instead of for the people of the City of Pensacola. The fueling SASO plan was abandoned later in March. Mr. McQueen claimed that the process had become too expensive. What happened was that those expensive attorneys he hired told him that the city would lose a Part 16 challenge if the fueling SASO plan was adopted. That led to the latest plan, which is the one proposed today. If AROS can't meet the AMCG recommendation, and if AROS can't meet the AVCON recommendations, and if AROS can't legally be a fueling SASO, let's lower the FBO requirements to something AROS can meet. The new plan rejects the recommendations of all three of the consultants who've been paid to advise the airport on its minimum standards: AMCG, AVCON, and now even Mike Moroney, who is, I think, a full-time consultant being paid $66,000 a year. We hired Michael Hodges to take a look at this new plan. He has worked for the airport before. I think he actually consulted with Mr. Miller back in 2009 about some changes to the minimum standards. And he finds a great deal wrong with the revised minimum standards that you have before you today. Exhibit 30 in your package is a copy of his report. But what he finds is that the proposed revised minimum standards are arbitrary, they're misguided, they call for insufficient hangar space for an FBO, they have improperly vague parking proposals, they have an insufficient ramp area requirement, and that's the most critical thing. He says that a minimum ramp area of 5 acres was and is necessary for an FBO at Pensacola. That's 217,000 square feet, or more than double what is proposed for your consideration today. His opinion is that the proposed modifications to the to the minimum standards are contrary to industry standards, that they are contradictory to the recommendations of several consultants, that they are potentially discriminatory in violation of FAA grant assurances, and they create potentially unsafe operating environment, also in violation of the FAA grant assurances. The airport's federal funding will be at risk if it violates the grant assurances, and I suggest to you that it will have done so if these minimum standards are adopted, ignoring consultants' recommendations, relying upon non-objective consultant, and conducting farcical public hearings for the purpose of window dressing decisions that had already been made and were already being implemented. Now, Pensacola Aviation is entitled to due process and equal protection of the law in its dealings with the city and the airport. It did not receive proper notice or a proper opportunity to be heard in respect of the revised minimum standards because, as I said, the decision had already been made before the opportunity to be heard was provided. The airport failed over a long period of time to enforce its lease with Aeros, as we've demonstrated in the AVCON report and the letter from Mr. Wells. That resulted in unfair competition, which these minimum standards, as revised, will perpetuate. The airport also denied Pensacola Aviation its due process, contract, and equal protection rights in its handling, in the entire process from 2011 till today of these minimum standard revisions. The airport allowed Aeros to play an impermissible role in the drafting of the revised minimum standards, and the airport proposed revisions intended to benefit Aeros alone, despite the fact that the revisions ran counter to the recommendations of their highly paid consultants. Perhaps the most telling thing about all of this is that there are some real problems with the airport's minimum standards. Problems AMCG identified on March 15, 2010, and excuse my typo up there, but it was over 2 years ago. The poor organization, poor writing, poor formatting, poor definitions, redundancies, poor focus. These deficiencies have never been addressed, and they're not addressed in the revised minimum standards that you've been presented with today. So you can see that the goal here is and has been to benefit Aeros, not to improve the minimum standards, not to improve competition. And I ask you to do the right thing here, and I ask you to reject the recommendation for revision of the minimum standards. I'll be happy to answer any questions, and if there are none, I'd like to let Mr. Hudgens talk with you a little bit about the effect of this on Pensacola Aviation. Go ahead, Bill.
And Mr. Hudgens, can you keep it together? Because I think you have probably talked to every member of the committee.
Let me ask this, does everybody want to sort of take a break? And I would like about 15 minutes if y'all would let me.
Okay. Well, why don't we do 10 and not take a break?
Well, whatever.
Okay.
I'll do the best I can.
Okay.
And I know y'all already had a long night last night, and that you've had a lot to handle. Let me give this to everyone to look at or have as I...
Just give them to the clerk, please.
Say again?
Give them to the clerk.
Okay. you can let everybody have a copy of that. Let me look at it and make sure. Again, thank you all for giving us time. This is important to us. It's important to Mr. McQueen. It's important to Ms. Crawford. And so,
You need to be on a mic so that it
Oh.
can be recorded.
I am going to want to talk about that chart, so I'll yell from there when we get to it. I'm Bill Hudgens. I'm a partner with Bruce in Pensacola Aviation Center. We don't argue that standards set 30 years ago shouldn't be reviewed and looked at from time to time. We do argue that the level of change you're being asked to consider is not appropriate for this airport, and that these changes are really just designed to accommodate Mr. McQueen and what he wants to do at the airport. Pensacola Aviation is a citizen of this community. Mr. Dick Bennett, the elder founder of Pensacola Aviation Center, was a member of this community for over 30 years. He was a member of the Pensacola Rotary Club, Florida Aviation Trades Association, and late in his career he was inducted into the Florida Aviation Hall of Fame, so he was a pretty good fellow himself. Bruce Bennett, his son and co-founder, is a member of this community, having lived here, owned homes here, bought cars here, paid taxes here, and he works here. Bruce had to move back up to Pineapple, Alabama several years ago to help with family matters up that way, but he's been commuting down here to Pensacola 3 hours each way. That's 6 hours a day to stay involved and run Pensacola Aviation.
Mr. Hudgens, I'm going to, just for the record, acknowledge that all the people in Pensacola Aviation are terrific individuals. That's not what this is about.
Yes, sir. I'll get to the point. I'm sorry. I just wanted y'all to understand that we're citizens here too. Ms. Crawford's told y'all that the airport obtained funding from the Florida Department of Transportation and the Federal Airways and Development Trust Fund to develop the ramp and the infrastructure that Pensacola is now on, and that's true. She's absolutely right. We were in the middle of a lease in 1994 when the airport decided that we had to move. So the circumstances at that time legally allowed the airport to use those sources of funding to build that infrastructure. And the airport's now making a return from our lease payments on that infrastructure. That was fair, honest, nothing underhanded about that history. We borrowed money and built the facilities that we're on to do our part to meet the standards that the airport asked us to meet at that time. We meet those standards today. We'd like to plan to meet them again in the future. I don't recall any restriction on an investment for the second FBO, and I'd appreciate us being shown everything, Ms. Crawford, that's involved there with the lawsuit and the neighbors, because we keep getting different versions of what the settlement was, as I'll mention here later about the helicopters. According to what we've seen in documents, Mr. McQueen built the facility he has, not to be an FBO, but to support some other businesses that he owns, with the idea that he might get into aircraft charter at some point. His facility is presently on the corporate ramp with these other operators, as y'all seen. Ms. Crawford's told you that she can't build this second FBO on that second site, but from what we've understood, she can, and as she said, she would have to put it out for bid, so the risk there would be that Mr. McQueen might not win that bid process if it got to that. Most of you were apparently given a presentation by Mr. McQueen at some point, and Ms. Crawford has enthusiastically presented something to that effect today about fuel. Insinuation here, I think, is that Pensacola Aviation is charging too much for fuel. We enjoy a monopoly, or that our service level is below proper expectations because we don't have a direct competitor on the airport. This top line apparently is Pensacola Aviation, top of the chart. I'm going to ask you a couple of questions, Ms. Crawford, if you would. Number one, has anybody else gone down lately on their price also?
And,
They have.
They have. Follows a similar pattern, doesn't it?
and I'm going to open this up. You're supposed to address this through the chair, but for facilitation purposes.
Yes, sir. I don't want to.
Because I don't want to put Ms. Crawford on the spot because her boss is sitting right next to her. So.
All right.
Okay.
Well, I just think that in the interest of clarification of this data, that if she chooses to respond, I'm okay with her responding. And then I would have also asked her that if you think it makes sense to compare, and Mr. Walker talked about this same thing, do you really think that Pensacola Aviation in Ferguson Air or Baymanet Aviation or comparable situations? And I would, answer now or later, I don't.
Mr. Hutchins, that was not so much presented as the difference in the price. That was showing that with the possibility of competition coming on, that variance is narrowing significantly. And that's the whole purpose of that slide.
Yes, ma'am, and that's why I asked you the question. Does it look like Continental Motors and Fairhope's about to face a competitor? Is that why their graph looks the same as ours? And does it look like, who is that? Continental Motors and Fairhope's about to face a competitor? Is that why their line looks like ours? And does it look like Ferguson Air and Gulf Shores? And I'll tell you what I think is going on here. I think if you look at the smaller the airport, and I know this because I just went through this in Montgomery, a lot of us turn our fuel more quickly than others turn our fuel. And what you look at is, what is my cost of my fuel in the ground, and that has some effect on what you might do with pricing. So I think you'll find that these folks have followed the general market with what's going on out there, and I think you'll find that some of these smaller airports sit there with fuel in the ground, and they base their pricing because they don't have much traffic on what did my last load cost me. I know that's what's going on, and I'd be happy to talk to y'all about that as far as y'all want to go into it, because we've seen that where we are up in Montgomery.
I think the point that, just backing up Ms. Crawford here, is not so much that everybody tends to be tending downward, but that the gap is narrowed significantly since the threat of competition came in.
Well, I'll let y'all listen to what I'm presenting and listen to what you just said and listen to what Ms. Crawford just said. Well, we take a fuel survey every week. I don't see, as Mr. Walker pointed out, I don't see Mobile on here. I don't see Birmingham, Alabama on here. I don't see Panama City on here. I don't see Tallahassee on here.
Mr.
I want to know who picked these points.
Mr. Hutchins, I just mentioned to you that Mobile was not on there, but if Mobile had been, that they would have been either with you or just above you.
Right. And again, I would ask y'all to consider the fact that any conclusions drawn from this set of data don't include some other data that I think might show a different.
Ms. Crawford,
Yes, sir.
how many FBOs do they have at the Mobile Airport?
They have one.
That one, okay.
You know how many they have in Birmingham? They have one. You know how many they have in Panama City? One. You know how many they have in Tallahassee? One. Mobile had two until a couple of years ago, and they were both going broke. They consolidated back into one.
Mr. President, can I ask a question?
Yeah, yes, Ms. Deweese.
When I met with you and Mr. Bennett, we had a detailed discussion about fuel survey, that you do that weekly as a business practice to establish your, and so you have years of history of doing that survey.
Yes, ma'am.
And there is about 12 on here. How often do those change? Are there some that have been constant since the beginning of your surveys that you compare yourself to, or how do you establish that?
The pricing that we see moves around week to week, and what we do, we're updated each week by our supplier at this point. We were with Exxon Mobil for a long time, and about 3 years ago or so we went with AVCON, a different fuel supplier. So AVCON sends us information at the end of any week about what they anticipate the changes are going to be in jet fuel and 100 octane pricing. What they're trying to help us do is decide if we want to order a load to take advantage of a price reduction later, or do we want to delay a load if there's going to be an increase or something along that line. So we look at our cost on fuel also. The purpose of the fuel survey is we're calling other operators in other cities, and generally you'll see some smaller airports and some larger airports on what we survey. But the point is, we stay in the market with what we charge for fuel. And I have a comment here that I want to be very specific about. If you want to compare our fuel price as a full service FBO on a major airport with a fleet of fuel trucks open 24 hours a day, with over 100,000 gallons of fuel farm facility we have to maintain and keep, to Milton, Florida, or Baymonette, or Bruton, we're going to cost more every time. We have to. But if you compare us to, as I mentioned, Panama City, and I'll quit saying Mobile, Tallahassee, Nashville, Birmingham, Montgomery, or any other airports that are similar to us in size and facility and services that we offer, we're very much in line with pricing. We're very much in line with quality of service. Please keep in mind that we are competing. We're competing with these other airports. That's one reason we take that survey. A jet can come to our place from Tallahassee or Dallas or Nashville. A crew does not have to buy fuel from us. A private owner in a single-engine piston airplane making a trip across the Panhandle. You'll get on airnav.com where she got these prices, or you'll get on the AOPA.com site, and you'll study, you'll look at what's pricing. He'll make his decision to either skip us or land with us based on his shopping. We do compete. I want y'all to keep that in mind, and to accuse us of being a monopoly and overcharging or offering subpar service is just not the reality in which we operate. Do we mess up every now and then? Yes. We're not perfect as far as our service level. We might miss something occasionally. But the overwhelming majority of the reviews we get through different sources are positive. Back in our Exxon days with the survey, we get critique and we get praise. Same thing with the comments on AirNav. By the way, Innisfree gets nice comments on their site on AirNav. I think in the city of Pensacola, we are not an embarrassment to what we do up here at the airport for you. Ms. Crawford did also talk about Bruce saying that we enjoy the flight department, we like those people, and then I think you, Ms. Crawford, had just drawn an erroneous conclusion there that we're keeping our fuel prices high so we can subsidize the flight activity and have fun with all these wonderful, fun, interesting people. I think, again, you just missed Bruce's thinking there. If we weren't losing money with our shop and our flight department, we'd pay ourselves and our employees more. We wouldn't be adjusting this price of fuel very much. We're in the market. We know where we are with our fuel price. So I think to conclude that we're charging a lot so we can go over here and play with people is an erroneous conclusion.
Okay, Mr. Hudgens, go ahead and try to wrap it up here quickly. Yeah.
But this, again, is important to us, and this is the only chance we're going to have to be before you all.
And you'll get a chance to speak from your seat out here as the discussion goes on.
I'm sorry.
Yeah.
Get away from the fuel chart. My fault.
Okay.
Mr. McQueen did contact the airport in 2004 and express his desire, and he did his private fuel thing has been laid out. The airport in 2009 did get with an outside consultant. That first report came back saying 5 acres, 217,000 square feet. Somebody said, well, go look again. So they did a second study. Came back the same way. Go look again. They did. The third one came back at 152,000 square feet. And they came up with a fueling SASO. I won't go into detail about that. At the public meeting in January, where they rolled out the SASO idea, we were there and we presented some questions to Ms. Crawford and Mr. Moroney along the lines of, given these standards that you're proposing, why would anybody want to be an FBO anymore? Would you amend our lease to where we would also be treated as a SASO? If we're going to be competing with a SASO, let us be one too. Let's be fair. Mr. Moroney shot back at us and said, and what you're telling us is you want to terminate your lease and have us put it out for bid. That wasn't what we were saying. We said, no, Mr. Moroney, that's not what we're saying. We're saying if you're going to let him sell fuel and not have to do the other things required of an FBO, we'd like to have it that way also. Wouldn't that be fair? Why are we having to be hung with all these requirements, all this ramp, all these hangars, all this lobby, shop, flight department, complicated insurance coverages, and all these facilities we can't walk away from at this point? If he gets to skim the cream, do the easy part, jet fuel, and leave us with everything else, how's that fair? How's that all right? So we started talking to them, and they did decide we'll put the 100 octane on him. You know, we can sell 100 octane 10 to 60 gallons at a time. You can sell jet fuel at 1,000 or more gallons a time. So it's the easy part. I want to, last couple of points here, and again, I know y'all are tired. They did go out and find this generic study. This is a study that was a collaboration put out. The attorneys that Mr. McQueen is using were in on this study. Mr. Paul Myers, who did the second study, I'm calling it the ACMG or AMCG study, where he recommended 217,000 square feet. They wrote this study, the 497 airports, randomly selected, not necessarily all comparable to Pensacola. 30 or so of the 497 responded to the question about minimum ramp space. Took 18 of those 30 as a data sample. That's been called, I think, on your slide, an average. The FAA thought this was fine, that's an average. 102,000 square feet was the arithmetic mean, in other words, the middle number that happened to fall out of this data of those 18 airports. So ask yourself, what does 102,000 square feet have to do with Pensacola Airport, Pensacola International Airport? And the answer is absolutely nothing at all. It's an accidental number from a small sample taken from random data.
Okay, Mr. Hudgens, you know, I'd asked for 10, you wanted 15, you've had 20. So, yeah, so we are where we are, just going to open it up for discussion with council and the public, and you're going to get an opportunity probably to answer more questions than you ever thought you'd get. So,
all right, thank you very much.
Okay. Council? Mr. Lease.
I guess I'll start. I was hoping not to. I have a real problem here. I support both of these individuals and these companies. I think Mr. McQueen has done wonderful things on our beach, in our community, building the hotel on the other side of the airport. And I also support Mr. Bennett and Mr. Hudgens, their efforts as our FBO that we made a commitment with and entered into a lease quite a long time ago. And although this is being discussed or framed here today as an issue of fuel price was the request and that it's not an issue of these two companies, they're here and they're concerned. So it is an issue of these two companies. And there's really no way to avoid that. I trust our airport director. I look at what she's done and what she's been able to accomplish, and we have a beautiful airport. What I'm hearing today, I'm concerned about the process that was followed, that the request for being able to operate based on fuel price triggers a review of our minimum standards. Minimum standards are not approved by FAA, and they are copied and used and molded to our needs for our airport. So those reviews were done and constantly did not recommend what was being requested and asked for. I met with Mr. McQueen and understood their business perspective and what they're trying to transition to. And I also met with Mr. Bennett and Mr. Hudgens and asked several questions about the fuel survey. Was one of my important pieces of this because that's the request that everything is based on, that there needs to be better fuel prices. And I look at how they derive their fuel prices as a business practice and have for many, many years, and that is their income producer. But as the lease that we have with them that started in 1994, as an FBO and all the things that have been required of them over the years, that has been their business model. So today we're being asked to adjust our minimum standards to allow for this new business plan, Mr. McQueen to be able to operate as he wishes to. But I feel that there are portions of this that were not communicated to Mr. Bennett and Mr. Hudgens along the way, and that's where the flaw in this process appears to be. After I left my meeting with Mr. Bennett and Mr. Hudgens, I went to try to understand FBOs and how many FBOs are enough. I did a search, and I actually supplied this through Ms. Major to all of you in case you were as eager to understand this as I am, because it talks about evaluating the competition, okay, so creating fair competition. Fuel prices set aside, lease set aside. If we were sitting here today and we had no FBO, no nothing, and we had a brand new situation, we'd be having a totally different conversation because we would be talking about how much business is out there for fair competition. It's almost as if they were Christmas tree salesmen and we said there are 30,000 houses in our city and most people need one Christmas tree, okay? We don't need 2 and 3 in a house. That sounds like a simple analogy, and I apologize for that, and I don't want to minimize what we're doing here today. But I'm concerned that evaluating the need for a second FBO, it was contemplated earlier on when the move was made in '94, but the infrastructure was not put in, and a business plan was not put in place. I understand it's in a master plan that Ms. Crawford had referenced. But I think there's another component that has not been addressed here in this process, and that is, do we need another FBO? What's complicated for me to try to reconcile is the huge investment that Mr. McQueen has in his facility at Innisfree. It is a beautiful facility, and he has condominiums and hotels all up and down the coast of Alabama and Florida, and had hoped there would be more volume for that. I don't want to see his business investment close down and not be available to anyone. It is a nice addition to our community. But we have to ensure that fair competition and even playing field. So I need some clarification to understand you have a business that is an existing business with us that made the commitment long ago to be an FBO, that is operated as that, doing the primary and the secondary requirements for an FBO. And it has cost them money to do that. And I listened very closely when I met with them and understand what they have to do to be that FBO. And I'm not going to sit and read all of this to you, but one of the comments on this first page, and it's, I will give you the title, it's How Many FBOs Are Enough? Guidelines for Evaluating Airport Competition, and that it is just a recommendation from the National Aviation Transportation Association. It's a committee that was put together on airports. And it talks about how that competition is the lifeblood, but it says trying to understand whether competition at an airport represents an opportunity or a threat to existing businesses should start with a look at the airport's environment itself. So it's not just this fuel issue. I'm sad that we are in this situation at this point. I think there's a few steps in this process that still need to happen where the airport director can have more meetings with the existing FBO and also with Mr. McQueen. My first question would be to Mr. Bennett or Mr. Hudgens or the attorney. What's being proposed here today, the reduction to minimum standards, I hear the concern about the 5-acre minimum and the 217,000 square feet and how that, it appears we're going against those recommendations in all those reports. That aside, I'm having a hard time understanding this new minimum standards that you've proposed, how that will affect your business operation financially and also operationally, because Ms. Crawford said you would now have a choice of secondary operations that you could do and still have to maintain the primary ones under your existing lease. So do you understand my question? I'm trying to see how, if you had to operate under this new minimum standards, what it would do to your business.
I'll let them expound on it, but I would say if I'm asked to drop back, you know, to cut back in order to fit, not only would the services that serve this town be lessened, I would have to. I mean, and the extra stuff that this business does, but I've got people that work for me for 30 years. I'd have to let them go. And that affects me. I honestly, I can look at everyone that's been there 20, 30, 4, 32, 3. You know, these people have been here, and to ask me, that's how it would, personally, it would affect me financially. Personally, it would kill me. I wouldn't do it, and I'd frankly ride it in the ground first. And financially, it would just allow, I don't think the two FBOs would bring any more business to Pensacola. So you would effectively be splitting the business. And with that, I'll hand it off.
One thing that I would like to have gotten in, and I appreciate now getting a chance to, is that if this were to pass, and then if future actions don't correct it or whatever, we wouldn't plan, I don't think, on asking the city to take back half our rent to reduce our lease payment. Mr. Bennett negotiated a pretty good situation, we felt like, for everyone involved. It's an escalator that is based on inflation. You know, the rates we pay get adjusted occasionally. There's some days we need that entire 500,000 square feet of rent. We get a certain weekend in here when the Blue Angels come or something, we need all that ramp. There has even been one occasion in Pensacola that came up the other day we were talking about where we even tried to use some of the corporate ramp to put a few people. So it's a feast or famine business. You go out there on some days and there's just hardly anybody out there, and on other days we're very utilized. So it's like the fire department. You've got to be ready, and you've got to have a facility there just in case. Ms. Crawford's right. We don't have the total volume now we used to have. All of our fuel volumes have decreased some with the economy in general. But no, what we'll do, I think, you know, when what Bruce and I have talked around, and we don't have to do this yet, but we will draw down. We're not going to just keep sitting there losing $100,000 in the shop and $100,000 flight part. We're not going to keep doing that. You can tell us we're stupid business people already. Bruce and I came up with our fathers. We love aviation. Mr. McQueen loves aviation. He's involved. We all like what we do. And there's been an FBO obligation to serve the public. It's why these standards were there all this time. It says you're going to sell fuel. You're also going to do these other things that aren't as easy. But the community needs them and the flying public needs them, and you're going to do them. We're going to do them, and we're going to comply with our lease, but we will not do them to the degree we have been doing them. And if we get a chance to sub it out, we'll try to look at that too, but we're going to be careful about who we sub it out to. We're going to be responsible for not just any old junk operator in there. We can't get certain people in there and insure them. It sounds easy to go out and get an outside shop to come in here. Well, you get an independent mechanic or something that, you know, yeah, I'd come do it. Well, he can't insure it. He can't name us additional insured. He can't meet the insurance requirements that y'all have of us. So we will adjust. We're not going to go broke over this if we can help it. Now, that said, we can subsidize this thing indefinitely, the whole business, I'm saying. If Mr. McQueen comes in somehow and starts selling fuel and bids on other things that we do right now, and the prices all get driven down, and we all look like Bruton and Bay Minette up there instead, we can feed it. We can feed it from now on, and he can too. If that's what y'all think makes a good environment, then that might be what happens. But we're not going to die or starve, and he won't either if he doesn't get this or if he does get this. But that, I think, is kind of where we are with what would happen. Does that answer your question?
It does. It clarifies a lot. My other question would be for Mr. McQueen, for creating a level playing field, that if, like I said, in a perfect world, if we had this move in 1994 and we had two people who wanted to be an FBO, we would have had totally different considerations how this would have been negotiated and discussed. And we have a facility already built that wants to become, as I understand, a SASO, fueling SASO, which is a new concept, but only do that. So if you're looking at fair competition, and that's something that the FAA expects you to look at, could you operate having to do everything that an FBO does? Could you operate your facility with those requirements?
We are not proposing a fueling SASO. If this
So what is being
FBO,
proposed?
if this goes through, you will modify the lease requirements, and if and when Mr. McQueen or Innisfree would like to become an FBO, they will bring back to you a lease amendment, but they will be held accountable
So
to
they're wanting
each
to
and
be
every,
FBO,
each
all
and
of-
every aspect of the FBO requirements.
Okay, so then you have the infrastructure and the investment that the PAC has made based on their lease with us, based on the commitment that we made as an airport, as a city, all their infrastructure, and you're saying you're going to reduce the requirements of minimum standard, but not acknowledge all their investment in the infrastructure that they have already, but then allow a new FBO under the new minimum standards with the smaller footprint as far as the acreage, and combine that and I believe another site on the airport, the Gila Works, to get to your minimum, which it goes against all of the studies that were done to be contiguous and adjacent. So that's my concern, is that we're not creating a level playing field here. So if we were truly contemplating two FBOs, this fair competition concept that FAA expects us to do has not been followed.
May I respond?
I have to step out real quick, I know, and she can just respond, and I'll be listening. My child's called 4 times.
Okay. If Mr. McQueen or Innisfree elects to become an FBO or desires to become an FBO, and they have indicated such, one of the things that Mr. Walker indicated before is that we had been working on a lease amendment while we were working with the minimum standards. That, whenever we do a lease amendment, that's not unusual. We have been working on a lease amendment with Mr. McQueen. All of the time that we work on it, it's contingent that the city council approves the revisions to the minimum standards. That's not something that's done unfairly or unequitably. Whenever we're doing the lease negotiations, that's the way we deal with it, with that individual, and then we bring it to council at that time. If Mr. McQueen or them were to decide to become an FBO, when we bring before you the lease amendment, it will clearly define their operation plan, how they plan to provide the amount of hangar space that is required, how they prepare to provide the fueling that's required, how they plan to provide the ramp space that would be required by this. There is significant infrastructure improvements that would have to be made by any individual that would come onto this airport to be this FBO under these revised minimum standards. And Mr. McQueen could speak to that, or his desire or indication, if you would like.
I do just want to hear how they would operate if the standards were adjusted, or if what is existing based on the existing FBO's investment, if that would work for them as a business.
We did confuse the situation, and that's why I tried to explain that on the January 5th public meeting, we were presenting to the public a fueling SASO. But when I sent my notice, this does not include fueling SASO, based on our review of the situation and based on some other things that we had determined about being one of the first airports. There is one in Texas that does it. We would be probably the second. But based on the comments that were received back from the FAA, there is no fueling SASO. They do understand that the ramp space will not be contiguous or adjacent. That was clearly pointed out to them. And they also understand that we will be using the average mean from that survey.
Mr. McQueen, would you or one of your representatives respond, please? And just find an empty mic somewhere. That'll be great.
Can you repeat the question?
I'm just trying to find out our way through this, or my way through this. I'm not speaking for anyone else on council. I'm just trying to acknowledge the existing lease that we have and the investment of them as an FBO and their requirements over the years. And maybe if what is being proposed, I'm concerned about it not meeting the recommendations of many, many reports, how you would be able to operate under the existing minimum standards, if that is feasible, or what blending of what's being asked and what exists can happen.
I'll try to answer that. Currently, the current minimum standards calls for 500,000 square feet of additional ramp space, and the airport doesn't have that. So it's impossible to conform to the minimum operating standards on ramp space alone right now.
Okay.
What's being proposed is an average of the survey, and it's going to bring up that space to 102,000 square feet. That's 102,000 square feet of ramp space that I currently don't have. So I'm going to have to make that additional investment to come up to that minimum
And that's
standard.
the Gila Works, right?
Gila Works plus the area behind our ramp, behind our facility. You know, I've said it many times that, you know, the ramp space that Pensacola Aviation has, being so large, puts me at a competitive disadvantage, absolutely. It would be great to have 500,000 square feet available, but the airport can't provide it. I'm willing to take that risk. My capital investment already today equals and exceeds what PAC has invested. So as far as, if you're looking at the burden of capital that I've put into the airport, we're actually at the same, very close to the same. Of course, I'll be putting additional capital into the airport with this new minimum standard. As far as the risk is on my part, and I've done my analysis, and I feel like the risk is warranted to the investment. That's the business I'm in. I take risk. Hopefully, I'll make good decisions, and I've made more good decisions than bad. Not all of them are good, but this is one I think that is worthy of additional investment.
And then the primary and secondary services, and I think Ms. Crawford may have to help me here to understand, to create a fair competitive environment, you would have to do some of the other things that cost PAC so much to provide to the aviation community. We have to have them. My question is this, and this is where I need some guidance on the competitive environment. How much flight training do we need? How much maintenance? How much? It's the inherent cost of one company doing it. It doesn't make sense to have two doing the same thing. It's like we've had conversations about consolidation with other government agencies or departments and how to streamline it. Sometimes it makes sense and sometimes it doesn't. So I'm concerned that we have not evaluated if we can even support two businesses doing what would be required for an even playing field.
Currently, right now, you have two companies that do provide flight training. The secondary services provided by PAC right now are Hangar Keeper, Flight Training, and Charter. You have Sky Warriors, who is a subleasee of Innisfree, who provides flight training. So there are two flight training.
The military.
No, they're open to the public too.
Well, let me, George Siegler called me today.
Mr. Bennett, pull the mic over
I'm sorry.
closer to you. Thank you.
The owner of Sky Warriors is absolutely trying to get something done because two of them are not working. I talked to him before I came to this meeting about that very thing. It's a problem.
And you have 135 charter service, which is provided by PAC and Lifeguard Air Ambulance.
Lifeguard Air Ambulance, though, is...
No, they do provide regular charter services,
so you
too.
can go charter their
Yes,
plane. Do
I'll
people
throw
do
out-
that, though?
As much as I appreciate that y'all, some of y'all might want to say, well, PAC deserves some protection, whatever,
You need to move a microphone over.
The FAA is pretty clear, and we hope we're pretty clear. We had a competitor back in 1994. We've already had that. And the FAA is not going to allow Ms. Crawford or y'all or anybody to protect us from having a competitor.
Right.
And we
Talked about
are
that,
not
yeah.
saying to y'all, we don't want to have a competitor. Oh, we don't, but we're not saying that y'all should protect us from having a competitor. That's not what we're debating here. What we are debating is the standards that that second competitor ought to have to meet. And our argument is, our point is, we just think that they've gone way down below, and we'd be happy to talk some more with them about what is available on the airport. I know you want me to hush but please let me go through this about the old ramp. When we were told to leave that HeliWorks ramp in 1994, the airport told us, we're going to expand the airport over that way, the terminal. We thought it was a parking deck or something at the time. We were told, y'all got to leave, all this is going to go away. And we had a lot of the hangar buildings disassembled and put back together over on the new site, and the airport asked us at that time to leave one of the hangar buildings because they wanted to put their airport equipment in it, the maintenance equipment. So we, being good guys, we said, okay, we'll leave it here for you. Well, then they didn't really tear it down after all, and they wound up leaving all that there and leasing it to HeliWorks. And isn't this going to be funny if all that time later now, Mr. McQueen's going to wind up leasing the ramp that you made us get off of? We'd have been okay to stay there for a while. So it gets into helicopter traffic also. We were told when we had to leave, or when we were told to move, and we worked all that out with y'all, we had a real nice helicopter traffic trade with Fort Rucker back then. They were bringing their cross-country training to several airports, and we still have it in Montgomery. They come up there. But we were told you can't have helicopters over on your ramp. And we were told it was part of the settlement with the neighbors. They don't want that noise. And so for a while we tried to, the helicopters land over there on the old ramp. They said you can still do the helicopters over here. And we'd send a bus around there to get them and bus them back around. And the time you did all that, that was not service that the military was going to put up with. So we basically don't have helicopter business anymore. And that hurt us financially. I mean, that was a business we enjoyed having, and now we don't have it. And Ms. Crawford has said to us, I think lately, and please chime in, Ms. Crawford, well, I think you can have helicopters over there. We want to make, and if we can, we'd love to. But if we can't, and Mr. McQueen winds up over there and he can have helicopters and we can't, that gets to be something I think that needs to be worked out better than where it looks to me like it's heading right now.
I'm going to stop my questioning with this, and I'm not going to make a motion at this point because I know others want to speak, but I just want to say where I'm headed with this because I'm really concerned that the process is not complete here. I think that we're having to almost hear like judge and jury information, that there needs to be some more consideration given to this process that I've referenced. And it talks about the airport sponsor needing to have 3 things that they've done, and if they've been done, please clarify because I don't have a copy of them. That there be a demand capacity analysis looking at how much this airport traffic can support. Also return on investment or internal rate of return analysis and an airport's financial impact analysis. Just so we understand, are we creating this and killing a business, or are we creating 2 businesses that are going to fail, or what is the demand and our capacity to fulfill it with the infrastructure we have, because Ms. Crawford said we don't have the money to add more paved area. So I'm not going to make that motion at this point, but that's where I'm headed, that there needs to be some more work done between parties and the airport before we actually take a vote. Thank you.
Okay, I'm just going to come around this way. Mr. Gerald.
Thank you, Mr. President. Would you do me a favor and read the recommendation again? Because I want to keep us focused on what we're really talking about.
Yeah.
You know, I'm hearing a lot of technical stuff.
The City Council adopt modified minimum standards for services and activities at Pensacola International Airport.
Thank you, sir. As I listen to the technical and the managerial, I cannot in good conscience sit here and pretend to be an airport manager or airport director. And when I look at the documentation, the back and forth of the emails and the correspondence that's been going on, and it didn't start yesterday, it has numerous players in the game, and sometimes when we run out of reality, we attack the process. And certainly if the person who looks at the process and say, well, you know, I'm sort of at a disadvantage, this can go on and on, back and forth, forever. And due to the amount of correspondence that's been taking place, the decision has been placed in our lap to make a decision. And quite frankly, it was said earlier in this room that when our airport director brings forth a recommendation that she feels offers some advantages to the city. I doubt if we would ever determine here, if we evaluate the process, certainly you can find something that is not in your favor and you would be willing to change it or to modify it. And as long as this has been going on, I don't see the light at the end of the tunnel. What I'm willing to do is to accept the recommendation from our airport manager and allow the details to work themselves out. Because we can go around and around today, and as we hear the solutions that are being offered or the remedies, my decision would be to support the recommendation of our airport director and let these guys work out the details. We can't. We don't know enough about it. And to sit here and debate it and ask questions, it's kind of like one of my fellow councilmen mentioned yesterday. It's similar to kicking the can down the street. We don't have the answers. And we could sit here and get those explanations for the rest of this month. And I think it's something that the airport people need to work out between themselves. And we make a recommendation to either vote up our airport director's recommendation or to vote it down. But all of the other stuff that I'm hearing won't impact me personally, ever, as it relates to the running of an airport, you know, and I understand the competitive nature of what's going on. Certainly, I would not want to see a business die, but at the same time, I'd like to see a business grow. And we cannot have it both ways. We either make the change and move on, or we deny the change and go back to this. Thank you.
Ms. Myers.
I'm wondering if I can be called on last.
Sure. Dr. Wu.
I was going to make the same request, but it'd be hard to have two people go last. This is probably the worst situation that a council can be in, because what we have is two people that I know very well, two people I like very well, get themselves in a conflict, and all of a sudden it's put in front of us to be the judge. Horrible situation to be in. Horrible. I know and like Mr. McQueen quite a bit. I know Mr. Bennett. Know his parents. Knew his parents. For me, what it boils down to is this question going to be made emotionally or going to be made intellectually. If I went with the emotional side, I would say these are folks that have been doing business for us for a long time. We heard they're doing 3 areas. Out of the 3 areas, they're losing money out of 2. And we're on the verge of talking about tinkering with the only area that they're making money in. I look at all those folks sitting behind them. Some of them have been there 25, 30 years. And they're going to be impacted by the decision we make. On the other side of the coin, I have an airport director that we pay a lot of money and who I have a lot of confidence in. And we ask them to look at items and bring them to us. And to me, it doesn't seem to be very logical to pay somebody who's an expert in the field to give you advice and then turn around and not take it. It'd be almost like Mr. Bennett hiring his attorney and then not doing anything the attorney told him to do. But for me, and I'm not trying to influence anybody one way or the other because everybody has to come to their own decision, is the question that I asked when I met with Mr. Bennett and the group, is there anything being done that's illegal? Because if it's illegal, then I could easily say I object to it. Not the fact you don't like it. I don't like it, perhaps. It doesn't matter, but if I like it or don't like it. But is it illegal? In other words, is there something there the law says you cannot do this? And I cannot find that. As much as we don't like it at times, the basis of our country is capitalism and competition. My parents had a restaurant. At one time, it did pretty well because it was the only restaurant. If you go back to the city where I grew up, I think there are 30. You know, did I like the fact the other ones came along? No. Eventually, it put my father out of business. But did they have the right to come and do it? And the answer is, in my mind, yes. So I'm going to vote for the proposal on that basis. It's a vote that I make with not a lot of joy. But I'm making it based on intellectual reasons rather than emotional reasons. Thank you, Mr. President.
Mr. Vice Chair.
Thank you, Mr. Chairman.
Oh, can I say one last thing?
Sure.
I want this to go on record. When I met with the people, I told them I wish they got a six-pack of beer and got in a room and resolve it between themselves. And I wanted that just to be on record. Thank you.
Good idea.
No, I'm not going to touch that one. Go ahead.
You need a beer. I think we find ourselves in maybe a similar situation like Pontius Pilate in terms of washing your hands of the matter. The FAA didn't do us any justice in making this determination. And Councilman Wu mentioned about whether it's legal. And it strictly says out in this advisory circular that once an airport receives a request that you look at it, and if they don't meet the minimum standards, give you authorization to try to come up with something to establish minimum standards. I also noted in our airport director's presentation, I think I noted that you had an appeal process that you could take if you feel there's something that might not be suited. And I don't know whether that appeal process took place or not. The other issue that was raised during the presentation by Pensacola Aviation was the perceivement of discrimination, which really triggers a concern when you bring forth that word. Normally we think about discrimination on various elements which do not exist here. Maybe is it unfair treatment? I don't know, but I've toyed with this. I've had orientations and briefings by both parties, and we talked about the flaws being suspect, and that we did numerous going back and forth to see if it would fit a certain entity. I'm just willing to listen to some more of what my fellow peers have to say about this, because I'm teetering each way. And I think additionally the comment that Councilman Wu mentioned was the airport's director's recommendation. We are not experts, and I think Councilman Gerald also alluded to that. We are not experts, and at some stage of the game, we're going to have to rely on advice and guidance from the experts in that field. But I'm willing to listen to all this, and then maybe by that time I will have a clear delineation of which way I'm going to vote. Thank you.
Okay. Mr. Spencer.
Thank you. I want to go on the record to make sure that our clerk understands I will not be able to vote on this issue. I have an ongoing professional business relationship with one of the parties, that being Mr. Julian McQueen, and recognize that that does basically present a conflict, and I believe I'll have to fill out a document as such. What I do want to point out is that I think that what we have here is a case of, this is not a case of big business versus small business, and I recognize that that in itself creates a somewhat separate context or dynamic, and we have two small business owners, both who have demonstrated perseverance throughout the history of their basically development of business careers and business growth. They both demonstrate, as I said, perseverance and represent success can be achieved in the context of capitalism. And I recognize or appreciate that our role is, in my opinion, is to do our best to achieve a context for competitive providers. And but at this, as I said, I won't be able to vote.
Mr. Johnson?
Thank you, Mr. President. Yeah, first I'd like to say I've met with both groups, spent some time at both facilities, and I appreciate their time in explaining the issue. And then, but what I kind of circle back to is what Ms. Crawford said, and that's her recommendation to allow this competition. I just kind of keep gravitating to her comments. It's been mentioned that she's I think she said she's a 17-year professional in the aviation business. We pay her a decent salary to keep that airport running and efficient in the best interests of our citizens and community. And I just keep circling back to her saying her recommendation is to allow this to happen. I'm trying to, as Dr. Wu said, trying to take my emotions out of it, and just circling back to that. So my vote will be to allow this to occur based on the recommendation from our airport director, Ms. Melinda Crawford. Thank you.
All right. Mr. Johnson, do you know if Dr. Pratt's left for the day?
Yes, sir. She had to babysit her, and she only had, I think, an hour and a half or 2 hours, and well over that.
Ms. Myers.
Thank you, Mr. President. First of all, I want to say that I appreciate having the opportunity to meet with both parties, and this is a very difficult decision. Also, I did want Councilwoman DeWeese to know that I did not receive that document you have, and I'm not sure the other council members did either, that you said was sent by Elaine Major, but I'm not sure that it...
I don't recall receiving it either.
That it would change anything. I want to look at this, if I can, from more of a constitutional and legal aspect, because I am a very strong advocate for constitutional protection, due process, and equal protection of the law. And it appears to me that you all have, everybody agrees that you're not asking for special protection, because the FAA requires standards that allow for and promote competition. So we can all agree on that. I'm having a problem, however, in the business world. Regulations and rules often change for all kinds of businesses. And I'm having a hard time, though, understanding why you are being denied equal protection of the law or due process. Due process usually comes into play when a right is being taken away from you, especially a property interest. It appears that there have been 3 public hearings. Quite frankly, I didn't know about them. I assumed they were advertised. Is that correct, Ms. Crawford? And that through those 3 public hearings, you would have had input. And so I'm having a hard time understanding why you feel that you are being denied due process and equal protection of the law. Now, I'm inclined to vote in favor of the motion, because I do believe that we do live...
Ms. Myers, before you go on, and you'll get a chance to finish here, but you do have a question there, and I'd like to hear from Pensacola Aviation.
All right.
On the...
That's fine.
Due process.
Due process.
On the due process.
Well, as I said...
14th Amendment, I believe, is...
The 5th, applicable to you through the 14th.
Okay, can we back up? The President is saying the 14th Amendment due process, and you're saying the 5th Amendment due process has to do with taking of property without due process of law?
Yes, ma'am.
Okay.
The 5th Amendment, the due process clause is in the 5th Amendment. It's applicable to what this council does because of the 14th Amendment. The 14th Amendment makes the Bill of Rights applicable
right.
to the states. And first, we had 3 public hearings on the now abandoned fueling SASO. Each of those public hearings was a farce because before any of those hearings were held, the decision had already been made. What was going to happen. The minimum standard revisions had already been approved. They'd been decided upon by the airport, its consultant, and AROS without any consultation with anyone else. And that's a violation of due process. To afford a hearing that's a farce is a violation of the due process clause. But we have more here. We had those 3 hearings, and ultimately they abandoned that particular plan, and they've adopted another one where they're now ignoring the recommendations of the highly paid consultants. To answer Mr. Wu, he said, we've got somebody, we're paying a lot of money, we need to take her advice. But we've shown you that she paid a lot of money to 3 different consultants and got their advice and is not following it. So that may or may not be a violation of due process, may or may not be a violation of equal protection, but it's a violation of common sense. But the due process violation here lies in the fact that the airport authority and director made a decision to change the minimum standards and had a public hearing just for window dressing. The notice and opportunity to be heard required by the due process clause requires that they be a real opportunity to be heard, that it make a difference. And I suggest to you it made no difference what we said or what we did at those hearings because the decision had already been made. When you adopt the 102,000 square foot ramp area requirement without the work of one single consultant, there's no consultant anywhere that they are relying on for that 102,000 square feet. It is a denial of the constitutional rights of the folks that have been paying for 500,000 square feet for 18 years to do so without any basis at all. Cities, public agencies must have a legitimate basis for their decisions. If they don't have a legitimate basis, it's a violation of due process. There was no process here other than the consultation of this bogus FAA study that had 38 airports that we don't know where they are out of 490. So we contend that due process requires that if you have a hearing, you have a legitimate opportunity to be heard. And if the decision's already been made before the hearing occurs, then you didn't have a fair hearing. And that's a violation of the due process clause.
Mr. President?
Yes, sir, please.
Thank you, sir.
And Ms. Myers, you'll be able to continue.
Okay.
If I can just address a couple points there, some mischaracterizations, for lack of a better term. The airport director doesn't have the authority or the ability to adopt minimum standards. That's why we're here. So the allegations that decisions have been made is incorrect. The other point I think it's important to make is that we talk about 3 hearings in which, you know, were shams, but apparently they were pretty effective, because after those hearings, the airport director went back to the starting point and said, this isn't going to work. So, you know, we can call it a sham, but it's a sham that worked to the benefit of the attorney and his clients. So I just wanted to make those 2 points.
Okay. Thank you, Ms. Myers.
Okay. I think the city administrator makes a good point. That, you know, the purpose of this meeting here is to allow you to come before the government and have a hearing. And even if we vote for this or today, you still have another opportunity to, is that correct?
That's right.
You would still have another opportunity to come before this body and have more input. So I do feel that there is a due process procedure that is in place, that is being followed, because we're here today, we're having a very lengthy discussion. You've given us a lot of material to look at, and even if I support this today, it's possible between now and the next hearing we have, I may change my mind. I have not had a chance to look at the information Councilwoman DeWeese disseminated, or to look at all of these documents, because I just got it this morning. So, because the FAA encourages airports to promote competition, I am going to support this today. It does not mean that ultimately I will support it the next go-around. That's the position I'm going to take for right now.
Okay, thank you. Regarding the already having a decision, you're going to get a chance to speak again, sir.
I don't need one. I wasn't trying to say anything else. I apologize.
No, there's a gentleman in the audience that wanting to speak. And of course, our ever-present Ms. Dubuisson wants to speak too, I think, right? Okay. Regarding already having, you know, where it is you want to go and then coming to a public hearing is really not uncommon at all in this building. Let's just say up in the planning department, something's been identified by a member of the community, and they vet it, they study it, and they find a way to remedy it, and then it comes to the city council in the form of a public hearing. And then we get a choice to move to adopt it or not. And so I'm looking at this as, this isn't a public hearing, this is a committee of the whole. And if it passes here today, then you'll have an opportunity on Thursday night to come before us and speak. But it's really not uncommon when you have a professional staff, and sometimes they generate the ideas on their own, you know, of things that need to be changed. Or the state will identify for us things we must change. And it's just an idea of how do we get there. And so I don't want the public to sit here and think that this is a special exception just for Mr. McQueen, Innisfree, Arrow Rose. And so But I'm not going to weigh in, I'm not going to give my opinion on this one way or the other. I'm just going to wait for the vote and show that. But I do want to open this up to the public. The gentleman and Ms. Dubuisson, if they'll come forward, and then we'll give each side here a chance to do their closing remarks. Yes, sir. I have no objection, sir.
Like I said earlier, my name is Richard Jesmont, 323 East Ramona Street. I am the counsel for Lifeguard Air Ambulance, have been for over 20 years. Lifeguard's been, some of you, or most of you probably know, has been out at the airport that whole time, was originally one of the parties that over in where the hangar, or where the helicopter facility is now, and moved over, and has a long-term, I believe, a 50-year lease on the corporate side. Anyway, very long-term, expended quite a bit of money, probably not quite as much as Innisfree, because they have a really gold-plated kind of facility, but we're a little bit of a different operation, but spent a lot of money. We don't have a particular dog in the hunt as to whether or not there are two FBOs, and we're glad we don't. But here's what our problem is, succinctly. We have a 135 license, which means people charter from us. But here's what we primarily do. We are the fixed-wing aircraft operator for Ochsner Hospital in New Orleans. We are the fixed-wing aircraft operator for UAB in Birmingham. We are the fixed-wing operator for the neonatal part of the Sacred Heart Children's Hospital. And we have contracts on national organ donor transport. What we're concerned about is that the corporate ramp where it sits, and we are directly adjacent to Innisfree, that we believe, based on our aviation experience, or my client does, that there are going to be a number of aircraft, and certain large aircraft potentially, that are going to block our ability to run our business. And minutes count when you're transporting neonatal to UAB or Shands or wherever they're sending them, and burn patients and the same thing. I guess what we would like to see is, before you make any decision as to push this forward, is to have an actual, no one's talked to us. I imagine she's talked one time, but what are the specific requirements, the turn radiuses, how much ramp is actually needed? To adopt 102,000 square feet because you took an arbitrary number from a bunch of airports seems to me, although may be correct, I think what Ms. Crawford said, every airport's different. And this would be a different argument maybe if Innisfree was in a different part of the airport where we were. And so what we would like to do is say, hey, can somebody hire a consultant, probably those engineer consultants you guys had, and determine if there's going to be a problem with the ability of my client to use what he leased. He would also point out that we don't think, if in fact the second FBO is in that location, that there's adequate parking for the planes. He believes, or Mr. Roach believes, the parking for the ramp is already deteriorating with the usage that's there. A much increased usage will make it even a worse situation. Has anyone looked at that? And as I didn't want to be belligerent, but is there adequate parking for an FBO and for what we do in that facility? And we don't think there probably is, but there's been no study that we know of. So what we would really ask is that before you just pass this, that at least if you're going to do it, get somebody, a consultant, maybe an engineering consultant, to establish whether or not this is an adequate minimum standard for this facility.
Okay. Ms. Crawford.
I appreciate your comments, and actually I have had a discussion with John. He actually came, not only did I meet with him in private, but he also came to one of our public meetings, and he addressed those very same issues. I am not asking you today, I'm asking you today to modify the minimum standards as proposed. If and when anyone elects to proceed with being an FBO, at that point in time, it would require an amendment to their lease. And when they do come forward, they would have to provide an operational plan for activity on that ramp. And at that point in time, I could clearly add to you some of the issues that he addressed as far as parking, radius of turns on your aircraft, and also just the manner in which they are planning to operate.
Okay.
And that would be brought forward with a lease amendment. And if you elected not to do that, then their lease amendment would not be approved, and they would not operate as an FBO.
Thank you, Ms. Crawford. Ms. Myers?
Yes, I didn't hear everything you said, but, you know, I've been sitting here for almost an hour.
Pull the microphone up to you.
Use the mic, please.
3 hours. And, you know, these are the kind of things that we need to cut to the chase in here. Okay? These types of issues. So, but what I'm hearing you say is that those issues were raised in a prior public hearing.
They were raised in a prior public hearing. We addressed them. We indicated at that point in time, if an amendment is brought forth, that it will clearly have an operational plan and show how activity would be done on that ramp.
All right, let me ask you this. Between now and the second hearing we have on this, was that meeting taped?
Ma'am, I don't think there is. Thursday night is your...
Yeah, yes, the
No,
second...
I'm not talking about, well, it would be Thursday night.
Thursday night, that's right.
We had a court reporter at all 5 meetings, ma'am, and you're welcome to have those transcripts if you would like.
I just wanted the transcript of just that particular part of any hearing.
Okay.
But
I can get that for you.
Okay. And you can get that to me tomorrow?
Yes,
about
ma'am.
tomorrow? Okay,
If
thank
it's-
you. No, it may not be important to anybody else, but it is something I would like to have, for my own satisfaction that issue was addressed.
And again, I'll reiterate, if this does not allow your amendment of the, your acceptance of the modifications to the minimum standards, does not automatically allow anybody else to operate as an FBO. It would require an amendment to their lease, at which point in time you would have the decision of whether or not to approve.
Okay. All right, thank you.
Okay. Ms. Dubuisson? Yes, sir.
Dottie Dubuisson, citizen of Pensacola. First off, I want to request that anything that was presented in either hard copy or electronically be made immediately available on the city's website so that citizens have a chance to review it before your next hearing, because I believe a lot of new information was presented. The second thing is the process, which has been discussed and batted back and forth by all parties. Everyone who's heard me speak at any meeting knows that I'm a process-oriented person, and there were 5 public hearings. What I believe we observed today was one group believing they were already in the appeal process of something that has not been determined, and I would really encourage this council to look at the fact that a professional staff of this city has spent many months addressing this issue, and that to move it forward to where you can take any kind of actionable activity is important, because if not, we will just continue to have public hearing after public hearing and new proposals. I have been in at least 15 public hearings where a private group went to the city, went to the staff, went to a particular councilman, hammered out what they thought was the best proposal, went through all the questioning without ever calling anyone who was opposed to it and saying, hey, I'm looking to do this, so make sure you know that I'm doing it. Instead, it is the first time understood by everyone who's looking for it when it's advertised that there will be a public hearing about this. So the suggestions that the staff of the city have acted improperly, on one level, I believe, are absolutely not accurate according to the processes that have been set into place under the new administration, the new charter of the city. But I will point out that there are individuals who have been reflected in discussion here who are not part of this hearing, who are not here to discuss what their roles were, and that continuously appear to be intervening in conversations between members of the staff and the public. And I would extremely appreciate if the council could somehow get our city administrator and the entire staff to recognize that when one speaks for the city, everyone hears it. And so if we don't have one single voice and we have 5 different people negotiating issues that it can get confusing. So this presentation today has clarified what the issues are. Another thing that I would like to put out is that the consideration of the physical changes that people keep talking about, I do believe a feasibility study needs to be done for that, because you're basing your decision on what is required, what is needed, and what is in the best interest. How can you know that if you haven't had an exact review of that? The helicopter issue. I have sat in development meetings downtown where everyone talks about our great helicopter facilities. When we were talking about, do we need to add some to the tech center or down by the port in order to attract the offshore business, we were told we have a booming helicopter situation there. So that was enlightening and surprising and does need to be factored in, because you have a bunch of people who are out there looking for offshore development groups who are expecting that they're going to have helicopter access. There's been a lot of conflicting information presented today, and I don't envy you folks at all. This is why I will never be sitting in your spot, because there is really not a consistent pattern of information that you can weigh A against A in the two columns. Do we have an exclusive contract, or do we have a non-exclusive contract rate that this group has been paying? Because what I heard is that when they decided there was a need, the city stepped up and helped build the facilities that they have then had these years' worth of exclusive use, and so they have enjoyed a benefit that no one else has enjoyed. At this point, we're having competition say, hey, I would like to also weigh in there, and the opportunity for that same situation to be presented is apparently not possible due to the legal tie-ins from the neighborhood association. That needs to be ironed out, because if they are coming in with a benefit, then we're really not discriminating against them to create an equal playing field. And the final thing I will say is, at one point when I did work in the backwoods of Nebraska, Kansas, and Colorado, there were a lot of small airports that only could stay open because of the federal subsidies. So I'm very familiar with what a narrow corridor of profit most of these groups operate on. But in McCook, Nebraska, people going anywhere from east to west across the United States who flew within 1,000 miles of McCook flew into that community because of the quality of service, the food, and the attitude with which their planes were serviced. They paid a premium on air conditioning, on the gas and all of that, but they came because they felt good when they got there. And it seems that we have two groups who are saying that they want to step up and do this. I don't care how it irons out. If the company who has been doing it can modify their business plan to meet the market change, which is obviously occurring, if the new individual one to come in can add a dimension of competition and improvement to our city, we will all have won. But rather than looking at everything having to be an all or nothing, let's look at the fact that we in Pensacola need the additional service, and competition generally brings us all to our highest performance. And I thank you all for your deliberations.
Ms. Doris.
Thank you, Mr. President. You mentioned feasibility study. What are you contemplating with that? What do you mean?
I just would like to see some bottom line numbers. You know, how many people have we had to turn away? I mean, they made reference to the fact that they couldn't take care of everyone. How many people have gone to other airports because on a single day or after a certain situation they were not satisfied? How many people are doing that gas thing? I mean, surely you can run a survey or poll of the people who regularly use it, and how often do they go to another airport because they can fuel up there and then just come in and use our services for other times. I mean, people do create their work pattern around what works for their company. So we may be servicing a lot of people who come in and land at their facilities and don't buy the gas, but go, you know, an hour away and buy it where they can save, you know, the money. So I just think we need to look at what are the real costs of changing it.
Thank you.
Thank you.
Okay, gentlemen, who wants to go first? Innisfree or Pensacola? Final arguments.
Go ahead, Bill.
Thank you all again for the time you gave us here today, and I'll say that when we signed up for this, we agreed to meet proper minimum standards, reasonable standards. I'll repeat, we have not said today that we deserve to be protected. What we're saying is that in our opinion, and in the opinion of some other outside experts, the standard y'all are being asked to approve today is below a standard that makes sense for this airport. That's our opinion, and there are other opinions. We've played by the rules. We didn't ask anybody to change any rules for us. We've cooperated with everything the airport ever asked of us for the last 35 years and continue to do so today, except rolling over for these standards to be passed. You've got a successful, powerful, influential, popular member of the community who's asking you by way of the mayor and the airport director to change these standards to make it easier for him to come in. And we understand that process. He wants to make a better return on an investment that he originally made for other reasons. Neither Bruce Bennett nor Pensacola Aviation had the influence or political pull that Mr. McQueen has, and we never will. But we're still asking the council to look at this particular situation on its own merits, these numbers, this 102,000 and the other standards, and see it the way we see it, the way we described it here today, and vote not to approve these particular amendments, these particular changes. Thank you all.
One more thing, too. If I heard correctly, I was sitting back there, but I think Ms. Crawford said that what she wants to do is to adopt this 102,000 square foot ramp requirement, and then if somebody like Eros or somebody else applies to be an FBO, then they're going to determine whether or not that's adequate. I don't think that's the way to do it. I think a determination needs to be made before this council votes on whether or not 102,000 square feet is adequate ramp area out there. And so far, the only thing they've done is to review that study of 38 unknown airports and the average of those airports. So I would caution you and suggest to you that you ought not vote in favor of this until you've got some basis to believe that 102,000 square feet is enough ramp area for an FBO to safely operate at the Pensacola Airport. Thank you.
Ms. Crawford.
First of all, throughout your presentation, you picked pieces out of our documents and you represented them. On several occasions, you represented them incorrectly, and I would go through each and every, just like the 6 mistakes you noted in our committee item. But I will tell you, I don't think we have the time or you have the inclination for me to go through each and every one of them. Innisfree did not help to formulate this minimum standard review. The only individuals that worked together on this minimum standard review were myself, Mike Moroney, and Mike Godwin. Have I had discussions with each and every individual? I will tell you that I have. I did not tell you that a few moments ago, as Mr. Walker indicated, that you would come back and look at it. What I said was that if I recommend you approve these minimum standards, if an individual wants to become a FBO, I will bring that lease back to you and I will define how they are anticipating meeting the minimum requirements, how they will operate on that ramp, and I will also, as Lifeguard Air Ambulance recommended, I will have somebody look at the configuration of that ramp. That's what my statements were. There are no mistakes. Am I perfect? No. But the mistakes he pointed out on your beginning with made me look like I was not competent. The mistakes, yes, Mr. McQueen came to me in 10, but Mr. McQueen came back to me in 11. The conversations with PFC about how they use their fuel to offset their flight training and their 135 were instrumental in my decision in moving forward that the minimum standards have to be revised.
Okay, Mr. Reynolds.
Thank you, Mr. President. I would just like to review for you the review that the FAA had performed. They did a courtesy review, as Ms. Crawford has pointed out.
Speak up a little bit. I can barely hear you.
Yes, sir. I specifically said, or I just said that what I'd like to do is review with you the FAA courtesy review that they just conducted on the standards that are sitting before you here today. And I quote, "By using the industry average square foot requirement, it appears the city has set a standard that is obtainable and fair. We also believe the offer for existing tenants to reduce their leasehold to the new standards is more than fair. We have reviewed the minimum standards you attached, and they appear to be consistent with federal grant assurances." Now, what the attorney has stated to you on many occasions is essentially saying that none of this is correct. This organization has done its due diligence. This organization has done everything it's required to do and more on this issue. And you have the FAA, who's responsible for the overall oversight, saying that the standards are obtainable and fair. Now, I could sit here and continue to have one of my staff members be treated in the way she has been treated by the individual sitting at the table next to me. But I can tell you that it's time for a vote on this issue, and that is not something that I'm going to allow my staff member to do further. That's all.
Thank you, sir. My apologies to Ms. Crawford for allowing that to go on.
Well, Mr. Hall, let me say that that document he just quoted from, they have not provided to us, as is typical. We'll have to file a FOIA request, I'm sure, to get it, because they don't, I don't know if they've given it to anybody else, but they've not given it to us. So to come in here and to throw it up on the board and show it to y'all when they haven't given it to us, I think is inappropriate. I don't know what Ms. Crawford sent to the FAA, and I hadn't seen what they sent back. But I certainly would have some comments about it if I'd had an opportunity to see it.
Okay. Mr. Bennett, just very quickly, please.
Well, I just wanted to say.
Because we've got the CMPA coming in here at 1 o'clock.
Yeah, this is quick. I would say Ms. Crawford had some pretty nasty things to say about me, and I don't see where that came from. I'm shocked.
Okay, all right.
I just need one clarification.
Okay.
On this, the 102,000, that to have an engineered study or have that verified, if there is an application or an amendment to a lease for FBO operations, will that be part of the amendment? Will it be required?
Ms. Crawford.
If you require it, or if I'm directed by Mr. Reynolds, it will be required?
The reason I ask is that there's a current concern from Mr. Jesmonth, and there are other businesses right along there that would need that. I would like permission to meet with Ms. Crawford about this document that I have, because my concern remains about the competitive environment, about one business or two, and how we're making that decision to add an FBO. Although we're not doing that here today, that's where this is headed, and I would like permission between now and Thursday's meeting to meet with Ms. Crawford on this. I guess I need permission from Mr. Reynolds.
Yes, sir, that's not a problem.
Okay.
And I appreciate my honorable colleagues' input. Ms. Myers is invaluable from a legal perspective, and also Ms. Dubuisson. She always brings it in for a landing. I know this is going to be appealed. I see the gaps and the information that you were not given, and I don't think it's a flaw in the efforts of Ms. Crawford. I trust her as an airport director and her efforts. This I do want to discuss on the competitive issues, and I will do that before Thursday's meeting. So I am going to support this today, not because I support what I've heard today, but because the FAA courtesy review that was done, I still am concerned about this 102,000 square feet. If other airports have done it, I would love to know what those airports are and why they would reduce it down to that as well. So that's it.
Okay, Mr. McQueen? Okay. All in favor is a show of hands here. All in favor? Passes unanimously. All right. Thank you, and because this is a special committee of the whole meeting.
Thank you, Mr. Hall.
Council? Yes, thank you.